Good morning, everyone, and thank you very much for joining us for today's webinar, Architects and Prompt Payment under the Ontario Construction Act, and how does it affect your practice? My name is Felix, and I'm the webinar coordinator at the Continuing Education Department here at the OAA. We will begin today's webinar by acknowledging the land on which we are meeting and calling in from today. For millennia, the place we call Ontario has been inhabited by Indigenous peoples and nations who have been stewards of the land and are deeply connected to its rich cultural and natural landscape. We would like to invite you in a moment of reflection to acknowledge our shared responsibility to address past and present injustices and provide space for Indigenous knowledge and worldviews to shape the architectural landscape of Turtle Island. Before we commence, I would like to share some important information to ensure an effective and professional webinar experience. Firstly, please be informed that this session is being recorded for quality and educational purposes. Secondly, in order to maintain a stable internet connection, we have muted all participant microphones and disabled video feeds. Also, we highly encourage engagement through our Q&A window. Feel free to submit any questions you may have for our speaker. These will be addressed in the designated question and answer period at the end of the presentation. Kindly note, the chat function will be deactivated following this introduction. For those seeking continuing education learning hours, please note that attendance is crucial. A minimum of 80% attendance is required for these hours to be accredited to your OAA transcript. Please allow up to a few weeks for the processing and reporting of these hours. And lastly, please note that the presenter does not provide insurance, legal, or practice advice, and the OAA does not bear responsibility for errors or omissions in discussions during the webinar. For accessibility, we provide automated closed captioning service available in multiple languages to accommodate the need of our diverse audience. And now, I'm excited to introduce you to our speaker for today's session. Please welcome Jeff Scorgie. Jeff is a construction lawyer at the law firm WeirFoulds LLP with a practice that focuses on drafting and negotiating contracts and advising on other front-end aspects of construction projects. Jeff assists his clients in reviewing, drafting, and negotiating all manner of design and construction contracts and provide advice throughout the projects as disputes or issues arise. And now, let's turn it over to you, Jeff.
That's great. Thank you, Felix, and thank you, everybody, for joining us today. I think it's going to be a great talk through. Hopefully, you'll gain a good understanding of prompt payment under the Ontario Construction Act, how it works, and how it can affect your practice. So these are the learning objectives we're going to be covering today. So gaining an understanding of the core features of prompt payment. So we're going to walk through the various timelines, various requirements, notice requirements, all of that. So you'll have a good understanding of how the prompt payment rules work. Gain an understanding of the architect's role and responsibilities in relation to contract administration. Learn some key considerations when you're acting in the role of a consultant retained directly by the owner, as well as considerations around prompt payment when you are engaged as a sub-consultant or perhaps a consultant to a design builder. And as I said, we'll also be talking about contract administration and specifically things to consider and look out for in prompt payment when it comes to reviewing the construction contractor's invoices that it's submitting to the owner. And this presentation is indeed related to a new practice tip that the OAA released, practice tip 10.3, and you can find that on the OAA's website. And here's just a brief summary of some of the pieces of information that it covers, and I think you'll find that it is a good resource. And so in addition to this presentation, that's another resource that is available if you need more information or have questions in the future about prompt payment. And as Felix said, please feel free to put questions in the Q&A, and I will do my best to address all of them at the end of the presentation. So now, just to get started, I wanted to just quickly give a brief timeline of the Construction Act so you can just kind of understand where the prompt payment rules came from. And it's really part of an overhaul and update to the construction lien legislation in Ontario that happened over the past few years. So back in 2016, the government hired some construction lawyers to advise on what was then the Construction Lien Act and how it might be reformed and updated. They produced a report called Striking the Balance in April of 2016. And then that ultimately led to or was followed by the passing of the new Construction Act. So the Construction Lien Act became the Construction Act, renamed the statute, and made various changes to it. And the changes really came in two tranches. The first set of changes came in July 1st of 2018, and that related to changes around construction liens, substantial performance, holdback, all those sorts of things. And then in October 1st of 2019, that's when the new prompt payment rules were introduced in the legislation, along with adjudication, the new statutory dispute resolution process, which we'll be holding a webinar on next Thursday, so a week from today. So prompt payment and adjudication came into force on October 1st, 2019. And just before diving into the rules, I did just want to provide a quick primer. Some of you may already be familiar with this, but just the lingo and terminology used when we're talking about prompt payment and other aspects of the Construction Act. And that is specifically just around the names of parties. So if you look here, I've just provided here on the slide two examples of two common project delivery models: design, bid, build, and design, build. You can see in the first there's the owner who would have a direct contract with the architect, and then they would have a direct contract with the general contractor, who themselves would, of course, hire suppliers, subcontractors, and so on. And then with design build, similarly, the owner is hiring the design builder. The design builder has a direct contract with the architect, as well as direct contracts with the subcontractors. And so everyone's familiar with these, these terms, and certainly these are how the parties are referred to in the construction industry. But then if we go to the next slide here, and this is how these parties appear from the eyes of the Construction Act. So you can see there are really only, for the most part, there's some exceptions, but for the most part, there's really only three entities. So you can see in the design, bid, build diagram, there's the owner, that stays the same, but the architect is essentially a contractor, and the general contractor is also a contractor. And then everybody beneath the contractor are subcontractors. And similarly with design build, you can see from the Construction Act's perspective, the design builder is a contractor, and the architect in this case is actually a subcontractor because they do not have a direct contract with the owner. And that's really the key point I just wanted to drive home. When we're talking about the prompt payment rules, the rules are all framed around the owner will pay the contractor in a certain number of days, or the owner will issue a notice of non-payment to the contractor, and the contractor will pay subcontractors. So that's the terminology the Construction Act uses. Anyone who has a direct contract with an owner is a contractor. And if you're hired by the contractor, or then you're a subcontractor. So you're either a contractor or a subcontractor. There is no designer or architect or engineer or anything like that. So I will try to make that point as we keep going, as we go through the rules. But I did just want to make that quick explanation because that's how the wording of the Construction Act works. So here this is a kind of a highlight and a general overview of the prompt payment rules in a nutshell. So they are essentially new rules that have been introduced that require the owner to pay contractors proper invoices. We'll get into that in a second, within defined periods of time. So essentially, the owner must pay a proper invoice that is submitted by a contractor unless it gives the contractor a notice of non-payment. And again, we'll get into what a proper invoice is and what a notice of non-payment is. Contractors and subcontractors must pay those below them within a certain period of time, unless they deliver a notice of non-payment. Notices of non-payment, they are prescribed forms under the Construction Act. And again, we'll get into all of that. So they're prescribed document forms, and they are required to disclose all the reasons for why you are refusing to pay. So you record all of that. And then another important point to remember is that the prompt payment rules are mandatory. They cannot be contracted around or contracted out of. So even if you have provisions in your contract, payment terms in your contract or in your purchase order or on your invoices that both parties agree to, if they are inconsistent with the prompt payment rules, the prompt payment rules will govern over them. In that way, it's very similar to statutory holdback and construction lien rights. They cannot be contracted out of or around. And lastly, of course, for all of you as architects, the rules are both relevant to your payment rights and obligations, right? If you're hired by the owner, when the owner is going to pay you, when you have to pay your sub-consultants, but it's also relevant to if you're in the role post-design of performing contract administration. It's important to understand the prompt payment rules there because they equally will apply between the owner and the general contractor as well. So here's an overview. This diagram will provide kind of an overview of how the payment timelines work under the prompt payment system. So first, we're gonna, the top row here is the goal, really if assuming there's no payment issues, there's no disputes with invoices, this is how payment's supposed to work. So the contractor would submit its proper invoice, and we call that day zero. So it submits its proper invoice to the owner. And assuming the owner has no issues, it has to pay the contractor's invoice within 28 days. And that's 28 calendar days, not business days, not working days, 28 calendar days. And the contractor, or again, the architect, if you're in the role of being hired directly by the owner, has to pay its subcontractors or subconsultants within 7 days of receiving payment from the owner. And so on. Subcontractors have to pay their subcontractors within 7 days of getting paid. So it's everything. You really need to know your 7 multiplication of 7s because everything is 7 days. So everybody down the construction pyramid, down the contracting chain has to pay their subs within 7 days of when they received payment. So this is what it's supposed to look like if there's no payment disputes, no issues. Now, let's say the owner disputes the contractor's invoice. Then if it's not going to pay, then it has to, on day 14 calendar days after receipt of the proper invoice, it has to deliver to the contractor a notice of non-payment in the requisite form. Upon receiving the notice of non-payment in 7 days, the contractor will have to give its subcontractors notices of non-payment. And so on. Subcontractors have to provide their subcontractors notices of non-payment within 7 days. Now, another scenario, and we do see this sometimes, is where what happens if the owner doesn't deliver a notice of non-payment like it's supposed to, but then it fails to pay on the 28th day like it is required to. Well, in that case, it's similar to the second scenario. Everything's just shifted out. So day 28 comes, the contractor is waiting to get paid. It doesn't get paid. What does it do? Well, it has 7 days from that date, so until day 35, to give its subcontractors a notice of non-payment and so on. And what I will say is, of course, I'm assuming here that the contractor or the architect in your case, if you're hired directly by the owner, doesn't want to pay its subcontractors out of its own pocket. I mean, that is always an option, of course, but assuming you're going to rely on the owner's non-payment as a reason not to pay your subcontractors, then you have to deliver a notice of non-payment. And then let's say there is a dispute between the contractor and its subcontractor, or the architect and its subconsultant. then the contractor would get paid on the 28th day. Then within 7 days, it would have to give the notice of non-payment to the subcontractor, explaining for whatever reason why it disputes the subcontractor's entitlement to be paid. And again, so on. Subcontractor gives a notice of non-payment to its subs. And that process just continues. So that's a general overview. Now, to start, you can see there that the most important piece there, really the document that, or the link in the chain that starts all of this, is the contractor's invoice, and that's called a proper invoice. So what is that? It's the invoice submitted by the contractor to the owner, and it has to meet certain statutory and contractual requirements. So it's delivered by a contractor to an owner, and I get this question all the time. Subcontractors do not deliver proper invoices to contractors. The proper invoice is only the invoice that's being delivered by the contractor to the owner, and that's what starts the whole payment chain. Now, what is it? So as I said, it has to meet certain statutory requirements and certain contractual requirements. Now, in the statute, what you see here on the screen are the minimum 6 requirements. The 7th is any other information that's prescribed by the regulations. There isn't anything at the moment. So it's these 6 items your invoice must include in order to qualify as a proper invoice. And this is very important, because if you're missing any one of these items, your invoice doesn't qualify as a proper invoice, and that doesn't trigger the prompt payment rules. That doesn't trigger the owner's obligation to pay within 28 days. So it's really important that, in your own practice, you're reviewing your invoice templates and making sure they get updated to capture and include all these pieces of information. And similarly, when you're performing contract administration, you're reviewing contractors' invoices. And if your contract, your scope of services for contract administration requires you to confirm whether an invoice is a proper invoice, for example, it's important to know what these pieces of information are. Now, most of them will look fairly standard, but some of them are a little unique, which we'll get into in a second here. And I've highlighted the ones that in my experience have caused some challenges, and that I most frequently see being omitted from invoices, and as a result, the invoice being rendered not a proper invoice. So the first one is the contractor's name and address. That's pretty standard. That's on most invoices, of course. The date of the proper invoice, you have to include the date, but you also have to include the period during which services or materials were supplied. Now, I only flag that because a lot of the time I see on invoices that it will just say, March invoice or something like that. It won't say the actual period for services rendered March 1st to March 31st. That's what you would want to include. You actually want to make sure it says somewhere that you're covering the actual period during which the services were provided. Number 3 is also a very bizarre one. It's the information identifying the authority, whether in contract or otherwise, under which services or materials were supplied. Get a lot of questions about this. What is the authority? That essentially is the contract that you're working under, right? So what I normally suggest is what you'd want to look for is a clear reference to the actual contract, right? So, a lot of contracts have a contract number, a contract title, or there's a purchase order number, something like that. So you'd want to include that. You want to include that somewhere on invoices, on your invoice. Or if it's being, if your work's being performed specifically under a change order, for example, you'd identify the change order. Number 4 is you also want to include it. You need to include a description, including quantities where appropriate, of the services or materials that were supplied. So some sort of description of the work that was done. Number 5 is the amount payable for the services or materials that were supplied and the payment terms. I perhaps should have highlighted the payment terms as well, because I do sometimes see confusion around that. Now, a lot of invoices will include some payment terms. They will say, if they've been updated to align with prompt payment, they will say, net 28 days, and then maybe a reference to the interest that would be payable for late payment. But you do want to include that, or at least a cross-reference back to the contract's payment terms themselves. Number 6 is the name, title, telephone number, and mailing address of the person to whom payment is to be sent. This, of all of them, is probably the one I see that is most often omitted from invoices or just not included. And for fair enough reason, it's a bit of a strange requirement because a lot of the time, of course, the payment is being sent to an email address, right? If it's a electronic funds transfer, or just the mailing address of your office, if you're sending payment by check. Payment often isn't being sent to a specific individual, but that's what the invoice is asking for. Essentially, Bob Smith in accounts receivable. So that's a bit of a strange one, but you do want to include something there. So I often recommend put the individual who's in charge of the head of your accounting department or something like that, or maybe it's you, maybe it's the project manager, whoever it is. But that's one you want to look out for. And so those are the statutory requirements. Again, you want to make sure at a minimum your invoice always, your base invoice template, your company's invoice template always includes those. But as I said, it's not just statutory requirements. Proper invoices also have to include any other requirements that the contract specifies. And this is where, again, a lot of invoices will fall short of the definition of proper invoice, especially if the contract includes a lot of additional invoice requirements. So you always need to look at your contract, and ideally, if you're bidding on a contract, if you're pricing a contract, if you're negotiating a contract, this is something you want to look at, the payment terms, the payment section. You want to look at to see what else am I being asked to include with my invoices? And is the information that's being asked, A, clear enough that it can be complied with every time? It's not vague, confusing wording, and B, feasible. Right? Are these things that I will always be able to include every month? Because if it's something I can't include every month with my invoice won't meet the definition of proper invoice, and I won't get the benefit of the prompt payment rules. So it's important to always flip to that section in your contract and see what is being asked of. I've listed here some of the common examples you'll often see. Some of these more often in construction contracts, but some of them certainly you'll still see in design contracts and architectural services contracts. So a WSIB clearance certificate, statutory declarations. So in the Canadian construction industry, of course, we have the CCDC 9A statutory declaration that construction contractors are often asked to submit. Some owners will have their own customized statutory declaration that they'll want you to submit with an invoice, where they're essentially saying that you're confirming that all the amounts you've received in previous monthly payment draws have been used appropriately, have been used to pay your staff salaries and your sub-consultants and all of that. An updated progress schedule, sometimes that's a requirement. There can sometimes be very specific granular requirements. You have to identify any amounts being claimed under change orders or change directives. You have to list those separately. Maybe you have to provide your HST registration number. And then sometimes, depending on the nature of the contract, you have to provide backup documentation. So again, if we think about this from a contract administration perspective, if you're performing contract admin, in the construction contracts at cost plus contract, cost plus contracts will often have various additional invoicing documentation requirements, things like backup documentation from subcontractors, so subcontractor invoices, maybe even statutory declarations from sub-trades, bills of lading, timesheets. That's sometimes a requirement in architectural services contracts. If you're being paid on an hourly rate basis, right? If some of the services you're performing are additional services that are being paid based on your staff hourly rates, the owner might include a requirement in there that says you have to provide, timesheets identifying who performed what task for how long, all of that. So you want to make sure, bottom line, go to this section in your contract, ideally before you sign, make sure you review it, and then, you know, I sometimes joke, you want to cut this out and staple it on your wall, for, you know, or at least put it in your binder for the specific project to make sure that these requirements are being met every month, because you don't want your invoice to be offside for a technical reason, because you missed something in the invoice. And I did we did get a question that I'll just cover right now. There's a question: wouldn't the statutory declaration cover the time period portion of the proper invoice? So yeah, if we go back to here, there was you can see here I had highlighted the period during which services or materials were supplied, and I think what the question is asking is, well, if you're submitting a statutory declaration, isn't that essentially indicating what the period is during which the services were performed? And yeah, it's a good point. I mean, a lot of statutory declarations will often say that. I mean, sometimes they're just dated up to a certain date, but sometimes they will include a specific reference to the specific month or the period that the statutory declaration covers. And if that's the case, that's good. I still do recommend, though, on your actual invoice template, you should include an actual field for this, just to be safe. Because again, you don't want to get in front of an adjudicator, for example, which we'll talk about next week, who's a big stickler for complying with these requirements, and looks on the face of your invoice and sees you didn't specify the period during which the services were performed. So again, I do recommend that people be very cautious with these requirements and just make sure your invoices clearly spell all of this out. It's a good question, though. In terms of delivering proper invoices, so what the Construction Act basically says is the proper invoice has to be given to the owner on a monthly basis. So that's the default, but unless the contract provides otherwise. So you're totally free to have, you know, your contract structured on a milestone payment basis, right? So sometimes there's construction contracts, design contracts are structured on a milestone basis. That's fine. You know, that's not contrary to the Construction Act. So you can have alternative invoicing time periods. One thing I will note that's important to appreciate is that there's no requirement in the Construction Act to notify a contractor that the invoice is not a proper invoice. So again, you know, say you're an architect that has been hired directly by the owner, you're the contractor in that case, there's no obligation on the owner to actually tell you that your invoice is not a proper invoice because it's missing something, for example. And this is a real issue because, you know, effectively, you know, you could wait until the 27th day, and, you know, the 28th day is coming up tomorrow. You think you're going to get paid. You don't get paid. You reach out and ask the owner, what's going on? Why didn't I get paid? You were obligated to pay me within 28 days. You didn't deliver a notice of non-payment. And the owner says, oh, you were missing a statutory declaration, or your invoice didn't include your HSD registration number, and the contract required that, right? So that is a concern. So again, it's all the more reason. Now, some owners may nevertheless tell the contractor this is the shortfall, or again, if you're in the role of contract administrator, you may be telling the contractor, look, your invoice didn't include a few of these requirements, and you know that's great. But it's just important to appreciate there isn't an actual legal statutory obligation on the owner to alert the contractor. So again, it's all the more reason it's important for contractors to make sure their invoices comply with the proper invoice requirement. And the contract cannot make the giving of a proper invoice conditional on the prior certification of a payment certifier or the owner's prior approval. This is a really important qualification, and it's actually fundamental to the prompt payment regime and the updates they made to the statute. Because essentially what they're trying to do, the legislators are trying to do, was get away from the prior practice of owners requiring that contractors obtain the payment certifier's approval of their invoice before they could actually submit their invoice. And that was a practice that was going on for a long time on a lot of projects. And that is now essentially forbidden. It's prohibited. So this is the one specific requirement that cannot be built into the contract. And we still do see this a lot. We see a lot of payment terms in contracts, mostly construction contracts, that will say that, you know, the contractor can't submit its proper invoice until the payment certifier signs off on their invoice, or unless they've included a payment certificate from the consultant, from the architect, approving the amount that the contractor is claiming. That is now off the table. You can't do that. And if your contract has a clause saying that, that clause is void. So this is, and now there is an exception for P3's public-private partnership projects where that is permitted, but for all other types of projects, this is something you can't do. And so instead, there's been a shift towards structuring payment terms around the provision of draft invoices. Now, and we do have a question here about this, which I'll get to in a second, but what you can do in your payment terms, and we see this a lot in construction contracts, is basically ask for, before the contractor submits its proper invoice, it submits a draft invoice to the consultant, to the architect, to the payment certifier, and perhaps they have a meeting, the payment certifier can review it, provide some comments to the contractor. But what's important to note, the distinction with this process, a draft invoice review process, is that you can't make it a condition on the contractor to accept the payment certifier, the consultant's comments on their draft invoice. Because again, that would just be going back to the old regime, which is prohibited. So, you know, you can say to the contractor, look, our payment certifier is going to provide you with some comments and some suggested changes to your invoice, but we're not telling you that you have to make those changes. Because again, that would be contrary to this provision in the Construction Act. And there is a question just related to this point, that we often get draft invoices for review which are not proper invoices. Is there a time obligation to review these drafts? Or more importantly, is there a requirement to issue a notice of non-payment for these draft invoices? Again, great question. And the answer is no. So there's no statutory obligation or provisions in the Construction Act dealing with draft invoices. If there is a draft invoice process on your project, say on it for the construction contract that you're performing contract administration for, that's a purely contractual arrangement that has been put in place between the parties, between the owner and the construction contractor. And there is no obligation to respond within a certain period of time or issue a notice of non-payment. Again, that's really more, you just have to read the contract. Maybe there's a statement in there, for example, that the owner could be free to say in their contract, you submit your draft invoice to me and my consultant will get back to you in 5 days or 3 days. Now, I mean, that may be something you want to take a look at, a careful look at, and speak to your owner client if that's an unreasonable time frame. But from the prompt payment rule perspective, draft invoices don't come into play. The owner's payment obligations only get triggered upon the delivery of a proper invoice that meets all the proper invoice requirements. Now, notices of non-payment are the other kind of fundamental, key, important document to this picture here. So the notices of non-payment are, as I said at the beginning, these are forms that are prescribed by the Construction Act. So it's not just, a letter or an email that you send, your client is sending to the contractor. These are actual forms under the Construction Act. And you can find them online very easily if you just Google Construction Act forms. They'll come up and you can download them all in Microsoft Word files. I've put here, there's 5 different notices of non-payment forms. You can see them here. I've kind of summarized them on the right-hand side of the screen. And so the first one, Form 1.1, is the form that the owner provides to the contractor. And that's fairly straightforward. So that's the form that if the owner is not going to pay the contractor's invoice within 28 days, the owner would have to issue that notice of non-payment to the contractor. Now, the next two, Form 1.2 and Form 1.3, are the forms the contractor would issue to its subcontractors. And there's 2 forms, there's 2 options. So this is where it's important for contractors to, again, in your role as an architect hired directly by the owner, you'd be considered a contractor. It's important to consider which of these forms you are going to be submitting to the subconsultant. The first is a notice of non-payment where the owner does not pay. So this is where you have not been paid by the owner and you're relying on the owner's non-payment as a reason not to pay your subconsultant, right? Form 1.3, conversely, is not where you're relying on the owner's non-payment as a reason to not pay your subconsultant, but because you have your own dispute with the subconsultant. And so in that case, you're going to have to spell out in the Form 1.3 what your issue is. Maybe you have been paid for that work already by the owner, but you still have your own issue with the subconsultant. So that's where you would issue that form. And then the other two forms are the same, but just at the subcontractor level, Form 1.4 and 1.5. The first one is where you're relying on the non-payment by the contractor to you as a reason not to pay your subs. And the second one is where you have your own dispute with the subs. So it's important to understand the difference between those forms, and you want to make sure you're using the correct one in the correct circumstance. And again, as I said, it's just important to emphasize that the notice of non-payment is supposed to disclose all the reasons for your refusal to pay. So, don't be too short in that section in the form. You want to make sure you don't have to go on for pages, but you want to make sure you've spelled out all the reasons why payment isn't being made. And again, there's another question. I feel like I should just address this here because we're right on the topic. Who's responsible for writing the various notice forms, the owner or the architect? Most owners want the architect to write these. Again, great question. The wording of the Construction Act talks about the owner delivering the notice of non-payment to the contractor. So from that standpoint, it should be coming from the owner, but it is true that a lot of owners in practice ask, in the architectural services contract, in the scope of work, they're asking the architect to prepare the form for them. And if that's in your scope of services, then that's part of your scope of services. You'd be preparing the draft for them. But you do just want to tread carefully there because if there's specific issues where you're really drifting into the realm of legal advice. There's legal issues. There's legal issues that have arisen, or there's issues with respect to the Construction Act, with respect to the prompt payment rules that maybe the owner's trying to pressure you to prepare a notice of non-payment form with some very discreet or unique arguments that they're trying to put forward as a reason not to pay the contractor. That's where you don't want to be drifting into the role as their advocate or their lawyer, and that's where you of course want to be saying to them that they need to get their own legal advice if they're going to have it start making sorts of claims against the contractor. But yeah, it's long and short of it is it's certainly not uncommon for owners to be asking architects or payment certifiers to prepare at least the draft of that notice of non-payment form. And again, yeah, another question along these lines: would the contractor, the architect, have a form to issue to the builder, the contractor? So yeah, again, the owner, really what we're talking about is the owner this form needs to be sent from the owner to the contractor. And again, whether the owner is asking the payment certifier, the architect, to prepare the draft form for them, that's a contractual issue and a commercial issue between the two of you, between you and your owner client, to work out in your scope of services if you're going to provide that. So I just want to go through some of these scenarios here, and just so we can just clearly see where these forms are coming into play and how they're being and when you'd be issuing them. So again, this is the clear scenario where there's no disputes or payment issues but between the owner and the contractor. Again, whether that's a construction contractor or the architect that has been retained directly by the owner. So the contractor submits proper invoice on day 0. Day 28, the owner pays the contractor the amount payable in full less the 10% statutory holdback. Then day 35 comes and the contractor has to pay its subcontractors the amount payable within 7 days, and subcontractors have to pay their subs within 7 days. Now, I should have mentioned this at the beginning. These time periods are not static. So these dates, the owner paid within 28 days. It's within 28 days. It's not on day 28. So as long as the owner pays within 28 days, that's fine. It is free to pay earlier. If it pays earlier, that shifts everything. So if the owner pays the contractor on day 27 instead of day 28, well, then the contractor has to pay its subcontractors on day 34 instead of day 35, because it's 7 days from when the contractor received payment, right? It's not static, it's not fixed in stone. It's not day 35. Day 35 is as far out as it could be, assuming the owner makes the payment on the last possible day, day 28. But it's just important to remember that those dates in that sense aren't static, and payments could of course be made earlier, and that will shift the corresponding payment obligations downstream. So this is the example where there's a payment dispute between the owner and the contractor. So the contractor submits its proper invoice to the owner on day 0. Day 14, the owner has to give the contractor a notice of non-payment, disputing the amount of the invoice. Could be in full, could be part of it, but you would set that out in the notice of non-payment, how much, with the reasons. And again, that's form 1.1. Then the contractor has to pay the subcontractor on day. I think I did mess these days up here. I just realized. I'll get that fixed up in the slide deck that gets circulated. But the contractor would have 7 days from that point in time to issue the notice of non-payment, or to pay its subcontractors, and then so on. 7 days from there, the subcontractor would have 7 days to issue a notice of non-payment to its own subs, or make payment to them. Again, you're always free to pay your subcontractors out of your own pocket. You don't have to issue them a notice of non-payment, but assuming you're not going to do that, assuming you're not going to be financing the work or financing the services, then you're going to have to be issuing the notice of non-payment forms. And this is that scenario I talked about, where you'd be using likely be using the other form, and that is where the owner pays the contractor the amount payable, but the contractor has an issue with its own subcontractor, right? So the owner pays the contractor in full, but then the contractor has to give subcontractors notices of non-payment within 7 days of receipt of payment over the disputed amount. And then the subcontractor either has to, again, it's all in 7 days, has to pay its subs or issue them a notice of non-payment. Now, the important thing that I also want to mention, and this is going to drift into the webinar we're going to have next week about adjudication, but one of the important aspects about this whole process is that in the scenario where the contractor is where the contractor hasn't been paid by the owner, and it doesn't want to pay its subcontractors as a result of that, or a subcontractor hasn't been paid by its contractor and it doesn't want to pay its subs as a result of that, and it issues them the notice of non-payment. That notice of non-payment, which says, I haven't been paid, so as a result of that, I'm not paying you. In that notice of non-payment form, there is a statement, an undertaking, which states that the contractor is providing an undertaking to its subcontractor that it is going to commence an adjudication within the next 21 days. And you can see that there on the last example there at the subcontractor level. And so basically what this is doing is it's kind of a reverse pay when paid scenario. So the contractor is basically, the legislation is forcing the contractor not to sit on its hands, but rather to go off and chase the owner for the funds by starting an adjudication process against the owner and trying to recover the money. So in that way, the prompt payment regime is trying to do away with the impacts that pay when paid clauses were having on the industry, where contractors could theoretically just, if they had a pay when paid clause in their subcontract, they could just sit on their hands and say, sorry, I haven't been paid by the owner, and just shrug their shoulders at their subcontractors. The legislation now is essentially forcing them to go and chase the owner through adjudication and commence it fairly quickly, within 21 days. Otherwise, it's going to have to pay them out of its own pocket. So that's really the teeth of the prompt payment regime. I mean, among other things, including interest on unpaid amounts. It's forcing the contractor's hand. The contractor is essentially being forced to go commence an adjudication against the owner. Or again, you're always free to pay out of your own pocket. Again, if that's the decision that you want to make as an organization. We want to pay our subcontractors and just have our dispute with the owner. That's something that's always, again, is always free to you as an organization. But that's a commercial and risk decision that has to be made. Now, I wanted to go through some specific considerations for each party in your different role in under the prompt payment regime. So these are specific considerations for contractors. So again, this of course is from the construction standpoint. This would be a general contractor or a design builder. But as an architect, this would be where you are the prime consultant. You're the architect. You've been hired directly by the owner. So first and foremost, as I've tried to underscore, you want to make sure you're revisiting your company's invoice templates, making sure they are updated. What I suggest is updating your standard template form that always gets issued so that it always meets the 6 statutory requirements, but then having some process in place where you're making sure at the beginning of each job, your invoice template for that job is updated to also include any contractual invoice requirements that are in addition to the statutory requirements. So making sure that that process is in place internally. And that's the second point. Are there any additional proper invoice requirements prescribed by your contract? And again, ideally, you would have also considered that, if you can, at the bidding stage or at the contract negotiation stage. Do you have processes in place to track deadlines? This is also important. Again, prompt payment's been around since, as I showed at the beginning, October 2019, but I do still certainly hear from a lot of folks who, for whatever reason, just haven't really caught up with the times, and their internal accounting procedures are still kind of on the old system, and they're not issuing notices of non-payment. They're not keeping track of payment deadlines. You really want to make sure that you're getting on top of this, and that you're putting in place some system to, okay, when do I have to send notices of non-payment to my subcontractors, right? And whether that's some sort of calendar or some sort of tickler system, but something in place to be keeping track of those deadlines. And as a payment certifier, that's important as well. You want to be able to make sure you have a clear insight into when invoices are being submitted, when draft invoices were submitted, when the notice of non-payment has to be sent out, and all of that. And also making sure you are sending notices of non-payments to your subcontractors. And I just note that because I've seen many cases where contractors, and again, this includes consultants that have been hired directly by the owner, appreciate the change in the legislation that they are now getting paid within 28 days, or that's the obligation on the owner to pay them within 28 days. But they're kind of ignoring or not appreciating the importance of paying their sub-trades within 7 days, or just as importantly, delivering notice of non-payment within 7 daes. Because what you want to avoid is a situation where you didn't deliver a notice of non-payment to your sub, but you short paid them anyways. You have some dispute with them. You could be putting yourself in a position where the subcontractor could now bring an adjudication, commence an adjudication, against you, just based on the pure technical grounds that you didn't issue a notice of non-payment to them. And under the Construction Act, you're obligated to pay them because you have to pay unless you submit a notice of non-payment. So delivering those notices of non-payments are absolutely fundamental because you don't want to be found stuck in the position of receiving notices of non-payment, receiving payment, and being, making the decision, we're going to short pay a sub consultant for one reason or another, but we didn't send them a notice of non-payment within the requisite amount of time. Now we're stuck having to fight an adjudication, and we don't have a good defense against this technical non-compliance with the statute. So sending out those notices of non-payment is absolutely critical. Now, specific considerations for subcontractors, and there's a few more of them because there's a lot of challenges with subtrades with respect to the prompt payment rules and various things you really need to consider if you're in the role of the subcontractor. Again, I use that in air quotes because from your perspective as the architect, this would be not only where you're a subconsultant to a prime consultant, for example, you'd be considered a subcontractor under the statute, but also when you're in the role of the architect who's been hired by a design builder. Because again, going back to that diagram I showed at the beginning, in that case, you would be considered a subcontractor under the Construction Act. So these are some important things to consider in the role of a subcontractor. Now, the Construction Act does say that the subcontractor can request from the contractor confirmation of the date the contractor gave its proper invoice to the owner. And it does say the contractor has to respond as soon as possible. But the subcontractor can only make this request if it has its own subcontractors. So if you're the end of the chain, if you're a subconsultant, right, if you've been hired by a design builder and you have none of your own subconsultants beneath you, it's just you, according to the words of the Construction Act, you can't make this request, unfortunately. And I'm not entirely sure what the reason for that was, but that's what the statute says. The other concern with this provision is that it just says the contractor has to respond as soon as possible. There isn't an actual deadline, like 20 days or 10 days or something like that, which is a bit of a concern. And the concern about this is because as a subcontractor, your rights under prompt payment are all contingent on the contractor submitting a proper invoice. So you really want to know when they're submitting the proper invoice. Now, you might have a copy of the prime contract, the contract between the owner and the design builder, the owner and the prime consultant. So you may be able to review the payment terms and see in there when the contractor is required to be submitting its invoices, which is good. But what if the contractor doesn't comply with that, right? And you're just left in the dark. Now you can count, 35 days from when the contractor is supposed to submit your proper invoice. But again, if payment doesn't come, you don't know if that's because the contractor didn't submit the invoice on time, or maybe its invoice was missing something, so it didn't qualify as a proper invoice. That's why the owner didn't pay. Unfortunately, as a subcontractor, you kind of lack the insight into that upstream process. There's also no right under the Construction Act to request information as to when the contractor received payment from the owner. I've given a few examples here, which I've seen a few times, where what if the contractor fails to include in its proper invoice the work you've performed, the services you've provided, right? As a subconsultant, for example. Because the contractor's obligation to pay a proper invoice to a subcontractor only applies to the payments it receives from the owner for the services that you have performed that were carried in that invoice. So if the contractor, for some reason, doesn't include your invoice, doesn't carry your services in its proper invoice to the owner, that's a problem, because technically you're not getting the benefit of the prompt payment rules because it's all contingent on your work being carried in the contractor's proper invoice. Similarly, what if the contractor fails to submit its proper invoice on time? Again, it's just late or it's missing something, right? It doesn't include that WSIB clearance certificate that had to be included pursuant to the terms of the contract. So given this, if possible, what something that should be considered, again, if you're in this role, is trying to negotiate some clauses into your contracts to address these issues if you can. And again, I certainly appreciate that a lot of the time the form of contract might just be getting dictated to you, and you have to make the commercial decision of whether we take this contract, we try to negotiate it. Maybe we don't have that much bargaining power, that much leverage. We can't really push back on too much. Or it's just a hard tender process. We're just bidding and the contract's not up for negotiation. Those are all commercial considerations you have to take into account. But if you're in the position to be modifying your contract with the party who's hiring you, or include terms, in your proposal that would get incorporated, hopefully into your contract, these are some of the things you would ideally you'd like to address from a invoicing standpoint, prompt payment standpoint. And and a good example is a positive obligation on the contractor to include in its proper invoice all the services that you perform. So actually, a contractual obligation, you must, if I invoice you on time, you must include the services I performed in the invoice that you submit to the owner. Similarly, an obligation to notify you of the date it submitted its proper invoice. Yes, you can ask them for that under the Construction Act, but why not have an actual contractual obligation that specifically says, you have to notify me when you submit your proper invoice, and potentially some repercussions if they don't submit it on time, because that's essentially going to be prejudicing you from the perspective of the prompt payment rules, because you won't be getting the benefit of those timelines, of those payment timelines under the Construction Act. So something like, if you don't submit proper invoice when you're required to, or you don't carry my services in your proper invoice like you're required to, then from a contractual standpoint, my invoice will become payable within 30 days, right? Regardless of if you got paid by the owner, or maybe interest applies, something. Because again, the concern is just that you wouldn't get the benefit of the prompt payment rules if your invoice doesn't get carried. So those are a few things really to be considering. And conversely, if you're as the architect, you have your own sub-consultants, these are some things to be watching out for that your sub-consultants might be asking you to include in the contract in that case. And then lastly, I also just wanted to cover some specific considerations for payment certifiers, and if you're in the role of contract administrator, administering a construction contract. There's a few things here to consider. So first, you want to make sure your contract is clear as to what your obligations are related to reviewing the construction contractor's proper invoices, and how, of course, you will be paid for those services. Now, if you're using, for example, one of the OAA's standard form contracts like the 600, it, of course, has the schedule of services that you would go through and review, and you check off what your scope of services is during contract administration and how you're being paid for those. Is it captured in your fixed fee? Is this an additional service that will be payable based on your hourly rates? You obviously want to be clear from that standpoint. But you also just want to be clear on the wording, because sometimes we will see language owners will use in their contracts that might say something like, in the architect, the consultant will ensure the contractor includes all the requirements that it has to include in its proper invoice. That sort of language is problematic, not only from an insurance standpoint, because that's something, you're essentially saying you're ensuring they're going to do something. Well, of course, the contractor is not under your control. You can't control what they do. You can only review their invoice and confirm whether the requisite information was provided, right? So you just want to make sure you're clearly carefully reviewing the language that's in your scope of work, and that you're not performing, taking on obligations that you shouldn't be. And that's also where the you would try to want to make sure that the language, like is in the OAA 600 contract, there's language that states that the owner, if it needs its own legal advice with respect to prompt payment and the application and interpretation of the Construction Act, that the owner is responsible for getting that advice itself, right? That's not your role as payment certifier. Also, again, remember that the proper invoice requirements are in the Act, but additional requirements can be in the construction contract. I do a fair bit of work with a number of architects, and I often, get questions about during contract administration and the reviewing of proper invoices. And a lot of the times I see that sometimes there's language in there that says, make sure you're submitting, make sure you're confirming all the invoice requirements in the construction contract are complied with, but the construction contract was never actually provided to the consultant, or you never got a copy of it. So you want to make sure, obviously, you're getting a copy of the contract that you're supposed to be performing contract administration on, so you can you can make sure that you're reviewing those invoices, and what the contractor has to provide. Again, as I mentioned, you can't control whether the contractor is complying with its obligations under the Construction Act. So, you just want to make sure that the language you're using that's in your contract, in your scope of services, is appropriate, and you're not making unreasonable commitments. And again, the owner should be seeking their own legal advice with respect to legal issues that arise related to prompt payment and their contractor. And I can't emphasize that enough, because this is a bit of a unique scenario now with prompt payment, where there can be, some of those timeframes are a little, can be difficult to interpret and apply, and sometimes it does get a little complicated. For example, if the owner is, if part of an invoice is going to be paid, but some of it won't be, well, now now there's kind of two timeframes going there. There's the time frame to issue payment on the undisputed portion, and that payment has to be made within 28 days. But then there's the obligation to issue the notice of non-payment. That has to be issued within 14 days. And if things are getting complicated, then again, you don't want to fall into the role of becoming the owner's, dispute litigation advocate or lawyer. So you just want to make sure that they're seeking their own advice when the time period when that's necessary. So that's the end of the presentation in terms of the content, but there's a few questions that I didn't have a chance to get to during the presentation that I'd like to cover now, and some of them are good, so I definitely want to address them.
Jeff, exactly. So if I can just jump in, just a reminder to our members, if you have any questions for our speaker, please feel free to post them into the Q&A window. Jeff is going to go through them now. Thank you.
Yeah, absolutely. Just feel free to post any questions you have. Some of these are great. So there's a question: can the notices of non-payment be by email? That's actually a great question. There was confusion around that when the prompt payment rules initially came into force, because there's language in the Construction Act that says any documents that have to be delivered under the Construction Act, under the statute, have to be delivered in accordance with essentially the court rules, the Ontario court rules, like a pleading, a litigation document, which have all sorts of complicated rules about providing effecting necessary service and all of this. But the regulations of the Construction Act do allow for notice of non-payment to be delivered by email, and you'll also see that sometimes that will be spelled out in the contract explicitly. Sometimes owners will state that the contractor acknowledges that notices of non-payment can be delivered by email, and proper invoices can be delivered by email as well. The only other thing I'll just mention that I should have mentioned when we were talking about the submission of proper invoices is that sometimes the contract, we're seeing this more and more, owners not only stipulating in the contract the invoice content requirements, statutory declaration, WSIB clearance certificate, updated schedule, all of that stuff, but also dictating precise requirements around how and when invoices can be submitted. So things like, your invoice has to be submitted to our accounts payable email address, or this document portal, you have to upload it, or you can only submit it during the hours of 9:30 a.m. and 4 p.m. Eastern time, this sort of thing. And so that's something else to watch out for. I will say there is I don't think there is consensus certainly in the construction legal community around whether compliance with those types of requirements, delivering invoice requirements, if you didn't comply with those, does that render your invoice not a proper invoice? I think frankly, there is disagreement, I think, amongst construction lawyers about that. But again, my suggestion is if you're in the role of, you're submitting your own invoices, you just want to make sure you're doing it to be cautious. You're following all the requirements. Just, make sure they're being submitted on time to the right email address and all of that. But delivery, that's a great question. There's a question here with regards to negotiating language in your services contract. The contractor you are sending your invoice will not know if his invoice to the owner is a proper invoice, and there is no mechanism or responsibility from the owner to confirm that a proper invoice was received. So even though you may have language negotiating your contract that the contractor advise you, they cannot. So yes, it's a good point in the sense that the contractor may not know if, I think what the question's asking is, well, the owner doesn't have to tell the contractor that their invoice isn't a proper invoice. So how can the contractor be, confirming to a subcontractor, I submitted my invoice on X date? Yes, that's true, but it's still fully within the contractor's control to make sure its invoice is a proper invoice. I mean, ultimately, it rests on the contractor's shoulders to make sure it's going through the payment terms and making sure its invoice complies with each requirement. And the point is that, I think as a subcontractor, again, say you're an architect to a design builder, or you're a subconsultant to a prime consultant, ideally you'd want to be pushing that obligation. That is out of your control. So you want to push that obligation, if you could, onto them, onto the contractor, and say that you have to submit your invoice in accordance with the payment terms. You have to make sure it's a proper invoice, and you have to carry my invoice. If I submit it to you on time, you have to tell me when you submit it. You have to tell me if it's delayed, X, Y, and Z. And again, potential repercussions if they don't, because if they forgot, say the contractor forgot to submit a WSIB clearance certificate, and that was a requirement for the proper invoice, well, it's unfair for you, who had no control over that, and that's totally unrelated to your work. It's unfair for you to be prejudiced in that situation. So that's where you may want to consider an actual contractual payment term beyond prompt payment, right? Something like, if you messed up your proper invoice, well, that's too bad for you, but my invoices will still, from a contractual standpoint, bear interest, be payable in 30 or 60 days or something like that. That's the sort of thing you may want to give some thought to. There's a question here: what's the suggested approach to take when raising concerns around problematic language in contracts? It's a great question. It can be a delicate issue. Of course, you're starting the project. You don't want to create issues. You want to get off on the right foot, all of that. I think the important thing, one thing I have strongly, there's two things I would say to this point. Firstly, you may be working with a client who's not aware of the prompt payment rules. I mean, this happens both because the client, it may not be a sophisticated client. They may not be used to familiar with the construction industry and how, what the laws are. And so in that case, you're kind of educating them and saying, look, these are the prompt payment rules that you're subject to, that I'm subject to, that sub-consultants are subject to, that your construction contractor is subject to, and your payment terms don't comply with them, right? And we need to revise them to align with that. I see this all the time where, it's an unsophisticated client, and I say that from the standpoint that they're not aware of the construction laws because they work in some other industry, and they say payment terms are net 60 days. Well, it's important to explain to them that's not going to work, and that's going to create the other point I'll make is that creates what you can tell them is that will create all sorts of downstream consequences because I won't be able to pay my sub trades in accordance with the prompt payment rules if you're paying me late. And it could spiral out of control. It could lead to all sorts of adjudications, right? Because sub trades, will not be getting paid in accordance with the prompt payment rules. So they're going to start adjudications. You may start adjudications as a result. And that's just not in the owner's interest. So it's in their interest to, be complying with the prompt payment rules. I think that's sometimes a message you can try to relay. But from a mechanic standpoint, I mean, if you're negotiating a contract, that's the sort of conversation you can have. But, sometimes it's harder than that because it's a competitive bid process, and the contract's not up for negotiation. So in those cases, you could try to take advantage of the tender question period. Normally there's a period where you can submit questions to the owner. That might be, an option to raise and say, look, some of the payment terms aren't in accordance with the prompt payment rules. That might be an opportunity to try and address that issue. There's a question for a design build project when the owner is the payment certifier. What are the main issues to be aware of? Would it be preferable to have the architect as the payment certifier in design build? That's going a bit beyond the prompt payment rules. It's a great question. That is a important topic, and there's lots to think about there. I guess what I'll say, I don't think we have time to dive into that issue in detail, but what I'll just say briefly is there's various things to consider with design build. If the owner's acting as its own payment certifier, I mean, there could be issues from a kind of competency standpoint. Are they, necessarily equipped to be doing that? Do they have that expertise? That's why often they will have their own payment certifier or their owner's advisor or, a quantity surveyor who's doing that sort of thing. Conversely, you sometimes see the design builder's prime consultant also acting as the owner's payment certifier. And that's a whole other topic because there you're in two roles, and you want to be, avoiding a conflict of interest, of course. So that's where if that's the road you're going down, you'd want to likely get legal advice and make sure your contracts are being structured properly to avoid, any sort of conflict of interest and that all the parties are on the same page. But again, if it's an unsophisticated owner, and again, I say that as, it's an organization that's not familiar, an individual that's not familiar with the prompt payment rules, you try to, bring this to their attention right at the beginning. Because again, even though the prompt payment rules are mandatory, you want your client to be aware of them from day one, so that they're aware of what their obligations are. Can you revise a payment certificate if a deficiency in work certified becomes apparent before payment is made? So payment certificates is a separate thing, and the prompt payment rules aren't dealing with payment certificates, right? And that's an important thing to remember. The owner's obligation to pay a proper invoice is not to pay the amount certified or to pay the amount stipulated in the consultant's payment certificate. That's not what the prompt payment rules are based around. They're just based on the amounts payable. That's the wording used in the statute. So if there is payment certification going on, if you're in the role of contract administrator, that's fine. And, you can, yes, you can, if you need to amend your payment certificate and the terms of your contract allow you to do that, that's something you can look at doing. But I do just want to underscore from the prompt payment standpoint, it's not really relevant. The payment certificate, again, the owner may rely on your payment certificate in determining whether it's going to pay the proper invoice and how much. But if you didn't issue a payment certificate, right, or you issued one and the owner disagreed with it, that's kind of besides the point when it comes to the owner's obligation under the Construction Act to pay a proper invoice under prompt payment. As the payment certifier, am I obligated to answer questions from subcontractors, such as a painter trade, as to when I issued a certificate for payment to the owner? No, you're not, unless your contract says otherwise, unless the owner says, you have to answer any questions that come in from subcontractors, then, I mean, no, there's nothing in the Construction Act, right, that as a statute that would obligates a payment certifier to be speaking with subtrades. And you ideally you would want to avoid that, because, it's really the contractor who should be managing communications with its subtrades. There's a comment regarding language in contracts. Seek out legal to review language. I mean, yes, absolutely, especially if, there's, again, until you get the hang of the, kind of prompt payment terms, or if you're unclear whether, certain payment terms are in accordance with prompt payment or are going to create problems with respect to your subconsultants, then yes, it's not the worst thing in the world to, at least initially, while you're getting comfortable with the prompt payment regime, if you're not yet, even though it's been around for a while, to get legal advice. There's a comment here. Some current projects have language in the contract that goes against the prompt payment rules. This has been noted by contractors and owner with verbal recognition. What are potential issues that could arise from this? And is it prudent to revise existing contracts? Another great question. My recommendation is to being a little more on the cautious side. Yes, ideally, you would revise the contract. That's great that the owner and contractor verbally have said that they're on the same page. And I have seen this situation before where, say it's an organization, maybe an owner from out of province, or from the US, who's not used to the prompt payment rules, and they have their own kind of standard payment terms that says pay within 60 days. And then there's a discussion with the contractor. There's everybody gets together, we explain, no, this prompt payment requires you to pay within 28 days. That's good. But, I still, my view is still, contracts should be written to align with the laws that are in effect. And so ideally, yes, I think to avoid confusion, I think it's kind of a recipe for disaster to have payment terms that aren't in compliance with the law. And you never know if the person who had that verbal discussion gets replaced, right? They quit and somebody else comes on the scene and they're not aware of the prompt payment rules and they just go by the letter of the contract. Well, that could be a recipe for some bad situations, right? So ideally, you would revise the payment terms to align with the prompt payment rules. There's a question here. As an owner and architect, we owners are disappointed that the certification process by architects has been removed, since owners rely on that certification. Other than review of draft invoices, is there anything more that architects can do on behalf of owners to ensure that invoicing doesn't exceed work being completed? So I think the way I think about payment certification is that really is between if the owner wants to have payment certification, and a lot of owners still do, right? Because they find value in that. Again, that's perfectly fine. There's nothing wrong with that. Just what my suggestion is just to make sure you align that process with the prompt payment timeframes. So, when I'm speaking with owners who are hiring a prime consultant who's going to do payment certification, I just say that, look, you just want to make sure that things line up, right? So if the consultant is going to issue its payment certificate, well, you need that piece of information. If you're going to rely on that, you need it by day 14, because you as the owner need to issue your notice of non-payment to the contractor on day 14. So, it doesn't do you any good to have the payment certificate issued on day 20, because by then you will have already had to issue the notice of non-payment. And you as the owner really need to know how much you're not paying you're not going to pay the contractor, so you can submit the notice of non-payment on time. So, you know, it's not that you have to do away with payment certification. It's just, you just want to make sure that's being done and that it's lining up with the payment timeframes. Under the prompt payment rules, and again, specifically around the notice of non-payment. And I think it's really for owners not to confuse payment certificates with notices of non-payment, right? That, again, that's great. You have a payment certificate, but under the Construction Act, you have to issue the notice of non-payment to avoid having to pay the contractor. So it's important for owners to appreciate that. There's a question: in the design build scenario, the contractor has not paid many of our subcontractor invoices. They have advised via email, voicemail that they have not received payment from the owner, but no actual notice of non-payment was provided and no indication they will pay us. Is my only option to make a claim against that they have failed to provide a notice of non-payment under the Construction Act? Yeah, again, you know, I don't want to get into the realm of providing specific advice, because every project's different. Every contract is different. All circumstances are different. But what I will just say is, you know, I'll just reiterate the point I made earlier, that again, this goes back to this fundamental issue of, back here on this slide, the last bullet point, why it's important for parties to be issuing notices of non-payment. Because again, the prompt payment rules are structured almost like a reverse pay when paid clause. They say you must pay unless you issue a notice of non-payment, right? So if you fail to issue the notice of non-payment, the party, you know, you in that case, as the question suggests, could commence an adjudication. So that's why issuing notices of non-payment are important. And if you're not getting notices of non-payment, then yeah, again, you may want to consult a lawyer, because you may be able to commence an adjudication, because that, you know, issuing notice of non-payment is a requirement under the Construction Act. You may also have recourse under the terms of your contract as well, in addition to the prompt payment rules. Would it be possible to get a copy of this presentation? Yep, the slide deck will be circulated after the webinar. Some clients still want to use the CCDC 2008, which is not in compliance with the prompt payment rules. Even though we advise them to update the current version of the CCDC 2, they often refuse. What can you do? Yep, great question. I see that all the time as well. I should have mentioned that. It's a great point. The CCDC 2 construction contract, that's a standard form stipulated price construction contract that I'm sure a lot of you are familiar with. Those of you who do payment certification, do contract administration. It was updated. The old CCDC 2 2008 was the old standard form. It was updated at the end in December of 2020. And the new CCDC 2 2020 was revised, and its payment terms actually do align with Ontario's prompt payment rules. So you'll see there's now a reference to payment legislation. The payment terms have been revised so that under the old CCDC 2, the owner's payment obligation under the contract was based on 20 days from when the consultant issued its payment certificate. That's now been changed so that it aligns with Ontario's prompt payment rules, and, you know, as well as the other prompt payment regimes that are coming into force in other provinces, so that it's 28 calendar days after receipt of the contractor's invoice. So that's great, because that's kind of now in alignment with the Ontario legal regime, which is great. What to do when an owner is using the old form? It's a challenge. Again, beyond, you know, all you can do is try to educate them and say, look, this is a problem. Your payment terms they're not in compliance technically with the prompt payment rules in Ontario. And you really should either revise them, you know, through a contract amendment, a change order, amending the contractual language if the contract's already been signed. So revise those languages if they're still insisting on using the CCDC 2 2008, even though the seals for those contracts are no longer sold or available. But if they somehow still have some of those and they're using a CCDC 2, that's really all you can say. You know, it's not, you can't force them to use to switch to the other contract, all you can do is, explain that, again, that they really should be aware and be getting advice on the prompt payment rules, and that, their construction contract doesn't align with the prompt payment timeframes. And that's not in their interest or the contractor's interest or the project's interest generally. When an invoice is received from a contractor, does the architect as payment certifier have exactly a maximum of 7 days to review and advise if there are revisions required to the invoice due to incomplete progress of work, or issue the certificate of payment if the invoice is confirmed proper? Does the 7-day review time begin the day after the contractor submits their invoice, or the same day? Are Saturdays and Sundays or holidays included as part of the 7-day review time? Okay, so great question. So just to be clear, if you're the payment certifier, if we're talking about standard scenario where the contractor's invoicing the owner and you are doing payment certification, in that case, you don't necessarily have 7 days. It's the contractor submits his proper invoice. That's when you start counting. You start counting the day it submits its invoice to the owner. The owner then has 14 calendar days to issue a notice of non-payment to the contractor. So the owner is going to want to make sure that its agreement with you as the contract administrator provides that you're going to be providing them with advice on that invoice, whether that's in the form of a payment certificate or just your comments on the invoice, at a minimum within 14 days from the date of submission of the invoice, because the owner needs to get the notice of non-payment out within 14 days. So that's the time frame they have to play with. Owners will often say in their contracts, you have to get me your comments on the contractor's invoice or the payment certificate within 10 days or 7 days or 11 days or something, a bit of time. So there's a bit of cushion to prepare the notice of non-payment and get that out the door. In terms of our holidays and weekends counted, they're not counted in the duration. So, when we're talking about 28 calendar days, so you do, that includes weekends, right? And holidays, and all of that. Now, if a date lands though on a weekend or a holiday, then you go to the next non holiday day. So if something lands on a Sunday, it's you go to the Monday. But yeah, we're talking about 28 calendar days, 14 calendar days, 7 calendar days. So you're counting weekends and holidays within that time period. Here's a question. Does this legislation apply on projects being built outside of Ontario where the owner and the architect are based in Ontario and have entered into an OAA contract? Another great question. The Construction Act applies, the property needs to be located in Ontario. So you don't look at where the parties are located. You don't look at the contract they used. And again, they may have chosen to use an OAA contract, some other provincial contract. They may have chosen their own bespoke contract, and the contract may even have a governing law clause which says that we're going to be governed by the law of Manitoba or something like that. But when it comes to the Construction Act, that actual statute, the Construction Act applies to projects in Ontario where the actual physical property, the land, is located in Ontario. So that's a great question. But I will just say on that point, though, that other provinces have similar legislation, and a lot of the other provinces now have introduced, well, Alberta and Saskatchewan, I believe, have introduced very similar prompt payment legislation. A lot of the other provinces are following suit as well, and they'll be introducing prompt payment legislation, in the near future. And the last question here is, if the owner does not pay, what legal avenues are there to seek payment? Yep. So that's join us next week, because we're going to be talking about adjudication, and that is kind of the other leg of the stool here that was introduced with prompt payment, and that's this statutory dispute process that I've referenced a few times in passing, and that is one of your remedies. I mean, there's other remedies. There's liens. There's lawsuits. Or you can sue for breach of contract, depending what the circumstances are. But adjudication is available under the Construction Act in Ontario for certain types of disputes. And one of those disputes is non-payment, or issues dealing with a notice of non-payment, right? So that's one of the remedies that is important to be aware of, and be familiar with. So we're going to be talking about that next week. That's next Thursday. So with that, Felix, I think we're just right on time, and that's the end of the questions. I'll just turn it back over to you.
Great, Jeff. Thank you so much for your webinar today and for going through all of the questions that had been posted into the Q&A window. It was nice and great having you. And as we conclude this webinar, I would like to draw your attention to several important announcements. The next webinar takes place next week on April 11th, also at 11 a.m. and also with Jeff. And the title is Architects and Adjudication under the New Construction Act, and how does it affect your practice? As mentioned, the OAA will report your participation in this webinar to your transcript. Therefore, there's no need for individual reporting on your part. And additionally, all attendees will soon receive the presentation file via email along with a link to submit your feedback. Once again, thank you very much for your attendance and have a productive and pleasant remainder of your day. Thanks again, Jeff, and I'll see you next week.
Great. Thank you.
Bye-bye, everyone.